Welcome to Educate and Act. This series, which is co-hosted by the Emily Taylor Center for Women and Gender Equity, the Center for Service Learning, and the Commons, is today additionally supported by the Office of Native American Initiatives and the Tony Johnson Center for Racial and Social Justice at KU, as we center the topic of the Indian Child Welfare Act, which was passed by the federal government in 1978. My name is Emily Ryan. I'm the director of the Commons, and I'm honored to be able to welcome this panel today, as well as all of you here in the audience. I want to remind us that while we will be addressing federal legislation which was passed in 1978 and is being challenged in 2022, we can also remind ourselves that peoples have governed themselves on these lands long before the signing of the Declaration of Independence or the US Constitution, and that these peoples who governed and lived here prior to that were forced to adopt a new system of laws as the United States expanded. It's important to note that the descendants of these peoples are still here today, and they are now subject to laws of current US policy. And as human residents of this land, we are all making decisions that have an impact far beyond our own species here. In present-day Lawrence, Kansas, we are residing on land nourished by both the Kansas River, which flows through to the north, and the Wakarusa River to our south. This place is home to human and more than human species, including plants like echinacea, silphium and milkweed, and animals like red-tailed hawks, king snakes, and bison. It's also a temporal home to many who have moved through this place, both by choice and by force. And in this change of season, we find ourselves amid a critical time of vulnerability and transience, in particular for those who find themselves on the move, which is modeled, of course, by the biannual migrations through this place made by the monarch and many others, of which we're seeing the tail end right now. This land is characterized by wetlands, rolling hills, and also prairie. As present-day occupants of the land, we are not far removed from a history that tells us the original human stewards of this place were forced to move when the US federal government took the land in 1825. As we know today, in the state of Kansas, this land is still home to many First Nations people, including the many students, staff, and faculty at both the University of Kansas and Haskell Indian Nations University, whose collective wisdom expands our potential as humans and relatives, and whose individual experiences and ways of knowing and relating to the land are vast and many. I offer this acknowledgement as a reminder that this awareness can lead us to act in accord with what we know, especially as we consider the history of our institutions, as well as our own individual efforts. So thank you very much for being here today and for committing to learning more about this really important topic. I want to introduce our speakers for today, who will then each offer short presentations about different elements of the Indian Child Welfare Act, how it serves communities across the country, and why it is currently being challenged. So our first speaker today will be Emily June Adams, who is an ICWA specialist at the U.S. Department of Interior, specifically the Bureau of Indian Affairs Office of Indian Services, and in the Division of Human Services. So Emily will present first today. And then we will have Sarah Deer, who is a University Distinguished Professor at the University of Kansas, who is a faculty member in the Department of Women, Gender, and Sexuality Studies, and the School of Public Affairs and Administration, and the School of Law. Then we will have Laura Ramirez, who is an Associate Professor of Practice and the Liaison to Native Communities at the KU School of Social Welfare. And finally, we'll have Missy Holder, who is an Assistant Professor also in the School of Social Welfare. And then once we have the presentations, we'll have time for Q&A. So please be thinking about what you'd like to hear more about or have clarified. And you can use the chat to do that, or you can raise your hand and we'll call on you later. So thanks again for being here. Emily, do you want to start us off?
Thank you. Thank you for that introduction. Ignash Wanixa, Emily June Adams, Kukukshash, Department of Interior. My name is Emily June Adams, and I go by June. And I have been working for the Department of Interior. It's under Indian Services, the Bureau of Indian Affairs, Division of Human Services as an ICWA specialist for the past 3 years. I am an enrolled member of the Yakama Nation, and I previously worked as a social worker. I have my degree in social work for Yakama Nation Tribal Naknawasha program. So I have some experience in child welfare. So when I think of ICWA, I have kind of this little story that I tell about ICWA that kind of puts it perspective, because as a learner, I'm kind of visual and we like storytelling. And we have this story about three sisters walking, you may have heard it, where three sisters were walking along the river, and they see all these babies floating in the river. So one sister goes and runs down there and grabs all the babies out of the river. Another sister starts teaching the babies how to swim. And the third sister starts walking up the river. The other sisters say, "Why are you walking up the river?" And she says, "I want to see who's putting those babies in the river." So when you think of ICWA, we are like the third sister walking up the river. So, ICWA starts right at the initial of Indian child custody case. All those areas are important. All three sisters are important. We're talking about child welfare, child protection. We're talking about ICWA. Child welfare could be the one that helped them swimming, the child protection helps saving them. We all have our role, but ICWA help happens at the initial removal of the children. So why was ICWA enacted? It was acted as a federal law to keep Indian children with Indian families. And it was passed in 1978 in response to a compelling amount of evidence of the high number of Indian children that were being removed from their families by public and private agencies. So in 1978, Congress seen this, passed it in response to that high alarming rate of Native children being separated from their parents instead of families. And the purpose was to promote the stability and security of Indian tribes and their families. Okay, so that's just a general. I'm just not going to take a long time because I know you have a lot of questions and answers at the end. But I want to go over, and I'll refer to BIA, Bureau of Indian Affairs. It defends ICWA, ensuring that generations of Indian countries' children remain with their families and their communities and are brought up within their culture. And so our role under the Bureau of Indian Affairs is we have a lot of responsibility as making sure ICWA is complied to. One of the roles that we do at the Bureau of Indian Affairs is we establish the ICWA designated agent list. And that is a list of tribal contacts that the tribe have designated to provide notification to. Now we do that as a federal publication every year. And what we found out with the publication is there was a lot of turnover because a lot of times they'll designate, other than the tribal chairman, they might designate a social worker. Well, that social worker might leave. And so it needs constant updating because we want to make sure that those ICWA notices get to the right person so the tribe can decide whether they intervene or not. So we just developed the website. We have an ICWA website and we update that ICWA designated list every quarterly. That's one of our responsibilities, to keep that updated so that the public's informed, so the ICWA notice goes to the right person that can respond to that ICWA notice in a timely manner. The other responsibility that BA has is we get copies of ICWA notices. Okay, if those copies are usually kept at our office and filed if there's no action needed. However, if the copy does not identify a child's tribe, parent, or Indian custodian, BIA has a responsibility of assisting the state or public or private agency in identifying the child's tribe, parent, or Indian custodian. And so there are 574 recognized tribes in the United States, federally recognized tribes. A lot of times a person, for example, I say I'm Yakima. Well, that's not your my federally recognized tribal name. So a worker might not know that I'm a member of the Yakima tribe unless my federally recognized name is Confederated Tribes and Bands of the Yakima Nation. So we assist agencies in making sure that they identify the right federally recognized tribe. A lot of some tribal members might call themselves Sioux, and there are 11 Sioux tribes in the United States, and there are 16 affiliated Sioux tribes. So the workers has to interview the family to find out which tribe, a Sioux tribe that child might be enrolled in. So we assist the state in providing them that list of all the affiliated tribes. The other role that we have under BIA is we do provide ICWA funding to tribes. They have been providing ICWA funding since 1994 to ICWA tribes on their tribal base. We also, starting in 2020, BIA started providing funding to ICWA off-reservation programs. We have a number of our people, Native people that live off reservation. So the Congress has allocated additional money to off-reservation programs. We also provide technical assistance to tribe. And one of the requirements of if an Indian child is removed is that the state agency will have to have a qualified expert witness. There are 12 BIA regions in the United States, and the regional office will assist in identifying a qualified expert witness. And the qualified expert witness has to be knowledgeable in that child's culture to make sure that it's not detrimental for removal of that child according to the culture. So since this is a university presentation, if you want to understand ICWA, first of all, the ICWA statute, reading that sets guidelines for the Code of Federal Regulations. And I'm constantly having questions where I have to research the Code of Federal Regulations. So it's really important to understand ICWA to look at 25 CFR. And one of the main questions that I receive at the Bureau of Indian Affairs is on ICWA eligibility. So 25 CFR 23.2 defines ICWA eligibility. And for a child to be eligible for protection under ICWA, they have to be enrolled in a federally recognized tribe. For situations where they're not enrolled, they have to be eligible for enrollment, and one of their biological parents has to be enrolled in a federally recognized tribe. So that would make them ICWA eligible. The other question we get a lot about is the ICWA notice process. And for the ICWA notice, cannot be sent to the tribe by email, fax, or phone call. The Code of Federal Regulations 25 CFR 2311 requires the requester to send it to the tribe, parent or Indian custodian with a copy to the Bureau of Indian Affairs, and it has to be sent by registered certified mail with return receipt. That's the only way that the ICWA notice will be valid. Okay. And the code authorizes BIA, if they don't know the child's tribe, parent, or Indian custodian, and authorize BIA to help with that and assist in locating and identifying that. BIA, in those kind of requests, the Bureau of Indian Affairs has 15 days to assist the requester in trying to locate the child's tribe, parent, or Indian custodian. There's a time limit on that. So in looking in the CFR, you go to www.ecfr.gov, chapter 25 for ICWA. I really highly recommend, we really updated our Bureau of Indian Affairs ICWA website at www.bia.gov, and it's BIA-OIS-DHS ICWA. Because on that website, you can, we have a map of all ICWA designated agents and where they're located in their tribal names, the agents' names and contact information, email, and everything there. We update that every quarter on our website. We also have a section, I want to learn about ICWA notice, explaining the ICWA notice requirements. And then we also have a section, and we get a lot of questions about legal options. I want to learn about my legal options, ICWA legal options. There's a section in there that can give you some guidance. BIA does keep on file adoption decrees. The state is required to submit adoption decrees, final adoption decrees to the Bureau of Indian Affairs. And we do keep those on record, on file, in case the adoptee wants that decree for enrollment purposes. We also keep on file all ICWA funded tribes are to submit quarterly and annual reports, and we use that data to advocate for ICWA funding in the future. And there is also a BIA guide and procedures about the final rule of 2016 on ICWA. It's a really long document, but it gives you updates on the final rule of 2016. So if you look that up on the website, it'll give you a lot of information, and I have an email in there and everything if you have any questions about ICWA. I don't want to take a lot of time because I know there's a lot of speakers. But in closing, I just want to say that every child matters. And I want to get that purpose, that point out, because we receive thousands and thousands of ICWA notice. But we have to research and give guidance to everyone because every child does matter. And it's really important to us at BIA to make sure that that child's tribe is notified, that parent's notified, and any custodian. And that's our main role in defending ICWA, is making sure that notification goes in. The tribe has the right to intervene on the case at any time that they want to. And it's really important that this whole process, and as a social worker, I don't just see a notice, an ICWA notice. What I see is a child. And it's just remember that this whole process with, if you're working in the field with ICWA, is that every child does matter, and we can make a difference by assisting them and learning more about the ICWA law. So that's my brief presentation. I'll let the other presenters present. Thank you.
Thank you so much. Professor Deer, if you want to go next.
Hi, everyone. My name is Sarah Deer, and I am a citizen of the Muskogee Creek Nation of Oklahoma. Very glad to be here today. Thank you for the invitation. Unlike the other speakers, I'm a lawyer, which can be good or bad depending on your perspective. But I want to talk about two things. I want to talk first about what ICWA does and why it was created in the first place, and then talk about the danger that ICWA currently faces, because there's a challenge to the constitutionality of ICWA. So the backdrop is the very, very high rates of child removal from Indian tribes throughout the 20th century. So there were certainly efforts to assimilate tribes over the years, that tribal nations should dissipate or disappear or otherwise be unrecognized by the nation, by the United States government. So there were a variety of tactics that were used traditionally to try to reach the end result of disappearing tribes. And one of the manifestations of that was a very, very high rate of removal by state courts. In fact, I think in the 1960s, there's some studies indicating that nearly 90% of Native babies born on a specific reservation were removed by state social workers for issues of poverty. And so the perspective from that kind of old guard of social worker were happy to remove Native children from their parents because they didn't see the Native parents or the community at large capable of handling these kinds of cases. And as a result, in the 1970s, many researchers and activists came to Congress and said, look, we're losing our future. State social workers are taking our children and placing them in non-Native homes where they're denied access to their culture, and the tribal nation is lost access to the future that child could provide. So given the high rate of removal and the fact that placements were largely with non-Native communities, Congress took action in 1978 and passed the Indian Child Welfare Act. And what the act does is it's a mandate on state courts. It does not apply to tribal courts. So when a state is seeking to remove a child, and by that we primarily mean foster care or adoptive placement, that state court has to notify the tribal nation of the child, so that they have an opportunity to intervene, or in some cases even transfer that custody case to the tribal court. So it prohibits or it limits the power of state courts to remove Native children from their families. And it has been a tremendous success. It's often called the gold standard of child welfare law, because what it does is it says, okay, a child may be in a home that is poor, and maybe a social worker might perceive neglect in those kinds of situations. But rather than removing them altogether, the goal is to find a tribal placement. Native parents who are foster parents or potential adoptive parents, that they should have basically the sort of first line of defense before removing the child permanently. And so what that's meant is a tremendous help to tribal nations to keep their future intact, right? And to make sure children are connected with their tribal heritage. So there have been challenges to ICWA over the years in the courts. There was one initial case in 1981, I believe, called Mississippi Choctaw versus Holyfield. And the law was upheld in that case. The challenge we are now facing, and I don't think I'm overstating this, is that ICWA is in grave danger as we speak. There is a Supreme Court case that will be heard on November the 9th, next month, a little more than a month from now, in which there are adoption agencies and attorney generals who are going to argue that ICWA is unconstitutional and therefore cannot stand as a law. What's frightening about this is not just that it could overturn ICWA, but that it potentially could upend Indian law as we know it. So the challenge, there's several questions before the Supreme Court right now regarding this. And the case is called Brackeen, here, let me type it in the chat, Bracken. And one great place to find a lot of information about any Supreme Court case is SCOTUSblog.org. And that's good for any Supreme Court case. So if you're excited about the Supreme Court cases, you can go to that website, and they have a page for every case that the court's going to hear. There are several questions before the court, but the most important one in my mind is the one that suggests that this is a racist law, that by providing these protections for tribes and tribal children, that this is somehow a racist law. That is dangerous for a couple of reasons. One is that the overturn of ICWA would mean that state courts could resume what they were doing up until 1978, which is removing children from their home without any notification or opportunity to weigh in at the tribal level. So it would go back in time to a time where children are vulnerable from being removed from their communities because state courts determine that they need to be placed elsewhere and don't have to prioritize tribal parents or tribal foster care or tribal adoptions. So that is a huge danger. But it implicates more than ICWA, because if ICWA is found to be a racial classification, it could be found that it's impermissible under the Equal Protection Doctrine of the 14th Amendment. We know that distinguishing or discriminating on the basis of race is subject to strict scrutiny by federal courts, which means that the government has to have an extremely important reason to discriminate on the basis of race. But ICWA is not about race. And that's where we're in trouble if the court takes this in a direction that I hope they won't. But tribal nations are nations, and they're sovereign nations. And tribal members are citizens of their tribe. So the challenge we face is, if ICWA is unconstitutional because it provides protection for Native children, and the court sees Native children as a race, they may indeed overturn it. And then potentially that has impact for all of Indian law, because all of Indian law is predicated on the notion of nationhood and citizenship, not race. So if the court decides that Indian people are a race, then that has devastating consequences, not just for ICWA, but for everything. I'm sorry, I get a little emotional about this because this is an area that I feel very passionately about. So the argument that tribes are making in response to these allegations of racism is that this is not a racially based classification. It is a citizenship classification, and citizenship classifications do not require the court to apply this very high standard of strict scrutiny. They can apply a lower standard, which ties into the citizenship and the sovereignty of the tribal nation. So one of the analogies that I make that might help people understand this a little bit better is there are American children in foster care in the United States who have an interested adoptive couple or parent in Europe. Particularly, there's Europeans in the Scandinavian countries who will adopt children from the United States. And I'm not talking about Indian children, I'm just talking in general about American children. And they're willing to adopt some American children who are stuck in foster care, right? And that's a good thing. But you don't get to do that without going through the State Department, right? You can't just take an American child to a foreign country and adopt it. The State Department has to be involved in that process. And that's a good analogy, because what ICWA does is it says, before you remove a child from parents who are members of a sovereign nation, the tribal courts should also have an opportunity to weigh in on that adoption or that placement. So if we understand this as citizenship and nationhood, it's similar to the State Department having to oversee adoptions to other countries. And tribal nations are, in a sense, sort of foreign countries. They're domestic, but they operate independently. So my fear is that the Supreme Court may take this opportunity to say that ICWA is unconstitutional, and therefore there's no protection for Native children who are looking for safety and security, and an application of ICWA that provides an opportunity for them to stay in contact and be raised within the context of that tribal nation. So it's an extremely important case. One of my fears is that we have a number of adoptive parents that are currently on the Supreme Court, and they may see this again as sort of an unfair limitation on who can adopt a Native child. So their background in being adoptive parents may play a role in how they view this case. But I can't emphasize enough the danger that ICWA faces right now. I have filed a brief along with a Cherokee attorney arguing that ICWA should be upheld in order to protect parents who are victims of violence from losing custody of their children. And so this is about really the future of tribal nations, and it's about the future of the lives of Native children. So I encourage you all to pay attention to this case. Oral arguments will be on November 9th. And I believe that you can still listen live to the arguments. So I encourage those of you who have an interest in this area to be part of this effort. The saving grace, should ICWA be overturned by the Supreme Court, is that many states have their own ICWA law, and those will still be applicable unless their state Supreme Court says otherwise. So there is hope, and different states have their own state ICWA law, so those will be in place should the federal Supreme Court overturn the law. So there's a lot at stake here. And I just want to thank all the participants for listening. Thank you, Mado.
Thank you, Sarah. Laura, would you like to go next? Or Missy, either of you? You pick.
I can go. Thank you. So Bijou, my name is Laura Ramirez. I'm an Ojibwe citizen of the Turtle Mountain Band of Chippewa Indians in North Dakota. Paternally, I am of Mexican-American descent also. As Emily was saying, I'm an associate professor of practice with the School of Social Welfare and have taught at KU approximately, 6 or 7 years. My ICWA intersects with my work through the school in a way that is sort of as an educator of social workers. So taking that inside look on how we can educate our social work students on ICWA and the damage that was done prior to enacting ICWA. So we've done this in the school in a couple of different ways. In my role as that faculty member, I had an opportunity to bring influence to the school's curriculum innovation that began about 5 years ago. And once we went through this process, it was really evident that we needed to move to begin to elevate our courses to infuse an anti-racist, anti-oppressive lens. And so it was through that lens that 3 new courses for the school were developed around issues that are important to Indigenous communities. So currently, our BSW program is offering two new courses, one on centering on decolonizing social work, and then one on intergenerational and historical trauma. And then we do also offer a clinical concentration course at the MSW level that's named Practice with Indigenous Families. So this group of courses really aim to bring an understanding of the policies and the practices that the U.S. government and social service organizations implemented and resulted in a lot of trauma and at multiple levels for many generations of Indigenous people. So aspects of the Indian Child Welfare Act is infused into these classes, whether it's analyzing the policy itself or the role that social workers played in inflicting trauma on the families. We also look at critically discussing why there was a need to enact such a law to protect our children, and then putting that act into practice when learning the social skills needed for the field. So this was one of the ways in which the school is taking that inside look and trying to educate current social workers that will be in the field very soon in the importance of ICWA. Our accrediting agent, our accrediting body, the Council on Social Work Education, is also doing this at a national level. So schools of social welfare are nationally accredited through this governing body. And recently, the Council on Social Work Education's Board of Directors endorsed the organization's statement of accountability and reconciliation for harms done to Indigenous and tribal people. So this statement was developed by a group of volunteer educators, practitioners, and students that are both Indigenous and committed allies. And it was done to acknowledge the harms done to Indigenous and tribal peoples by the social work profession in general. It's intended as a key resource for social work educators. The accountability statement documents how the social work profession really played a direct role in supporting colonizing practices. But it also developed a teaching guide that helps to address historical and intergenerational trauma. Child welfare in ICWA is mentioned in there quite a bit, as well as the boarding school experience, health disparities, along with mental health and behavioral health, research ethics, and then the present and future commitments around sovereignty and self-determination. So I think these ways are the ways that institutions of higher learning, or at least the one here at KU and many social work schools nationwide, are really trying to prepare our social work students in, fighting for ICWA, understanding ICWA, and implementing ICWA when it's necessary. So I'm going to go ahead and turn it over to Missy, and we can talk through those details later. Thank you.
Thanks, Laura. Missy, you're a little frozen on our screen, so feel free to start if you're there. Uh-oh. She's frozen for you too, right? Okay. All right. Well, while we're, I had a feeling that was going to happen. Okay, she'll be back in just a second, I think. I have questions already for all of you. Such great presentations. But I don't want to get in front of her presentation, so we'll wait just a second. We did have a question in the chat about these resources that are being shared, and we will include these links with the recording when it's available too, so that you can check out all these links at a time when you have a little more reading space. So.
Maybe we can share some updates for events coming up.
Please, Melissa.
Because I have some.
Go for it, please.
So the Native students in FENSA will be raising the teepee on Wednesday morning at 7:30. So if y'all are available and want to be there, the Office of Diversity, Equity, Inclusion, and Belonging will have coffee and donuts as well. So that's Wednesday, next Wednesday. I don't even know what today is, but next Wednesday, after Indigenous Peoples Day.
Wonderful, thank you. And then do you want to talk about the talk on October? Oh, there's a question about whether there will be a live feed of the TP raising. Most likely not. Lots of
that
photos
advanced
for
just
sure.
yet.
Yeah, we'll find the link to that. And do you want to also mention the 13th, the talk at Haskell? Send that next week also. Just looking on the DEI page.
Yeah, I think Lori's pulling it up too.
Thank you.
Yes, thank you. I'm putting the link in the chat. We have Deidre Whiteman from who's Meskwaki, Dakota, Ojibwe, and Hidatsa. She's the Director of Research and Education for the National Native American Boarding School Healing Coalition. And she will be here at Haskell Auditorium. We're so excited to have an in-person event. And that will be on Thursday, October 13th, a week from today, and it'll begin at 6 p.m. She is an Haskell alum. She's a social worker, and she's been doing, and her organization has been doing some wonderful work throughout Indian country, and because everybody's affected by this initiative that Interior Secretary Deb Haaland has begun on finding or making accountable the folks that have gone missing and have been buried from the boarding schools. So is everyone, let's see, I'll try to send that again. Make sure you can open that, but that's going to be sponsored by the Tony Johnson Center for Racial and Social Justice from the School of Social Welfare, KU Native American Initiatives, KU Native Faculty and Staff Council, and then the Hiawatha Center for Justice. join us if you can.
Thank you. Well, I'm sure that the most certain way to make sure that Missy joins us is if I start asking questions. So I'll just ask a question to speed up that process a little bit, which has to do with something that Professor Deere, you were talking about with regard to falling back to state policy and legislation. Would that just sort of parallel then what we're seeing with Roe versus Wade as far as it falling to the states then to come up with, yeah, there's Missy's back. But this is something I'm wondering about, I guess, as far as.
Sure. It's hard to predict what will happen if the court rules ICWA unconstitutional. There'll probably be some fallout that affects ripples effects throughout the nation. But depending on how the court writes the decision, whether it's narrowly written to apply to a specific situation or more of a broad general objection, constitutional objection to ICWA, there will probably be a lot of activity on the ground to try to figure out how to keep Native children with Native families. And yes, the fallout could be tremendous. And I don't know if that's answering the question, but it would, if depending on how narrowly or broadly the court decides the case, it could mean that ICWA no longer is applicable anywhere. And so the only way that Native children can stay with Native families is through a state government ICWA, something the state legislature has passed. So some states have that, some states don't. But what it would mean is anyone could be a foster or adoptive parent of a Native child and not notify or let the tribal nation know in any way. I'm hopeful that, I want to be optimistic that that won't be the case, but I think it's important for us to be realistic about what's at stake here, so that we're not caught off guard, and that we're prepared. It's a very painful case, regardless of the outcome. I have to admit that I'm pretty nervous about this one, but essentially the question about Roe versus Wade and Dobbs, I think there is sort of a parallel there. If ICWA is upended, then Native people will have to legislate or lobby for legislation at the state level so that they can protect Native children in a similar way, but only within their state. So I hope that's helpful.
Yeah, it was. Thank you very much. That's my own limitation on legal structure, so I appreciate you breaking that down. Missy, are you there?
I see her.
Wonderful,
Hi.
yes.
I don't, of course, the day of a presentation,
Of
right?
course, yeah. Well, Laura prepped us to say that it was a little spotty in the building, so yeah.
Yeah, so if you don't mind, I know we're kind of cutting it close to time, but I'll just share a little bit about my experience in terms of teaching about the Indian Child Welfare Act. So just again, my name is Missy Holder, and I'm a citizen of the Winnebago tribe of Nebraska. And I've been asked to share about the intersection between ICWA, my research, and the KU School of Social Welfare. And my colleagues here have already done a great job of laying the foundation about the Indian Child Welfare Act, the history of it, and then also what the KU School of Social Welfare is currently doing. So I'm going to talk just a little bit about me and my teaching prior to becoming an assistant professor at the KU School of Social Welfare, where I taught Indigenous students about the profession of social work. And one of the things that we often grappled with was the perception of the social work field in our communities. But we often challenged each other. How can we change that perception to one that is about advocating for people? And when I think back about those students, I recall that many, even of those students, didn't have a lot of knowledge about the Indian Child Welfare Act in terms of the history. They knew about it, but they didn't have that extensive history, what led up to it. So with that said, though, they did know generally a lot about the atrocities that happened against Indigenous people or communities. There were a handful of students who knew about ICWA, and it was often because either themselves or a family member was impacted by agencies not following the policy of Indian Child Welfare Act. And I did encounter some students who were removed from their families of origin. And they also understood that the reality of the foster care and limited access to their traditions was being impacted also. One of the things that I did see with the students who were at this all-native institution is that the institution itself provided a connection in a way to their culture. So it was kind of like a beginning process for them. So on the flip side, now teaching at the University of Kansas, I teach from a perspective that my students will have very little to no understanding about the history of Indigenous people and the US government, let alone understand the purpose of the Indian Child Welfare Act. For instance, or what I wanted to also mention is last week I moderated a panel on boarding schools. At that time, I shared with the audience members the concept that Indigenous academics such as Twyla Baker and Alex Redcorn refer to as translation exhaustion, which states that Indigenous scholars and other BIPOC people have to provide like this entire history from pre-contact to contact, even before they get to a place where they can address the topic at hand. But with that said, and the students that I currently work with who are very knowledgeable in other areas, I understand that the students were educated in a public school system that likely only taught maybe a chapter or even less on Indigenous people. And oftentimes it was focused on the discovery of America, right? I would also add that my courses, even though my colleague Laura mentioned that we have this curriculum innovation that did occur at KU, the classes that I teach are not the Indigenous focused courses. So when I am teaching about the Indian Child Welfare Act, it's often coupled with other policies that may be related to natives or other groups of people. So unless though my students or the students in the KU School Social Welfare take Professor Ramirez's class or a course in the Indigenous Studies program, they will only get an abbreviated version of policies like ICWA. And it's really unfortunate because it's highly likely the students that I'm teaching who are interested in working in the foster care system are these social workers who are going to be working with Indigenous families and on behalf of Indigenous children. So this makes my role and other educators who teach policies around Indigenous people important to the future of the profession of social work, as well as having that general knowledge about Indian Child Welfare Act. And we're running low on time, so I'm just going to skip about my personal research. And just real quick, my personal research looks at historical trauma and intimate partner violence and the connection of the two. But I will say that there are a few common threads between the Indian Child Welfare Act and my research, particularly being jurisdictional issues and concerns, and then the lasting impacts of intergenerational trauma. I was also asked to provide some resources for the audience members. And I think there are many places to expand one's knowledge about ICWA in terms of reading about it and listening. But I would caution that just because you've read about ICWA, that there's still a disconnect to understanding the pain among the families, the children, and the tribal nations. One of the things that I wonder is how one can comprehend the threat to tribal sovereignty and cultural traditions just by reading the law or an article on a particular issue. So what I would suggest for our allies who are in the audience to appreciate what is shared with you, and also find out how you fit into that role as an ally, because oftentimes they have privileges that we may not have, and that could potentially be helpful in terms of pushing the concerns or issues forward. I also wanted to share another reference relating to what Professor Deer shared. It's a blog that, or excuse me, not a blog, but a podcast that I recently listened to, and it's called This Land, which is narrated by Rebecca Nagel, and particularly season 2. And she lays out that connection between the Indian Child Welfare Act and the threat to tribal sovereignty by what she's terming, and we also hear this in social work, is following the money. In addition to, her walkthrough about this particular, these particular issues impacting the Indian Child Welfare Act. There are also resources on that page for survivors, for journalists. There's linked to personal blogs and documents that she identifies in her coverage of the podcast. I would also offer other ways that allies can use their privilege is to be being an active ally, is that if you work in the foster care system, to ensure active efforts are being carried out as set forth by Indian Child Welfare Act. You could also recommend policy and practice changes. So caseworkers automatically ask from the jump, is this child or are the parents eligible for tribal enrollment? Right there, and maybe some of the agencies are doing this, but ask what those policies are and practices are in terms of Indian children who may be in that potentially being removed from their home. The other way that individuals can resources that are out there and have access to those things is that requesting training on the Indian Child Welfare Act. And my understanding is through the National Indian Child Welfare Act site, you can request training from them, from their staff, to come to your organization. But there's also the option to do an online training through their site, and that's an individual training that you could do on your own. And then I think lastly, for individuals who are local to Lawrence, I would recommend funding or helping find a space for centers such as the Indigenous Community Center, so that they can host meetings and address these issues, identifying, cases that we could potentially work with the lawyers in the community, or just bringing light via social media. So that was my quick review. Sorry about the technical issues.
No need to apologize. Thank you. That was a beautiful sort of conclusion, I think, too, in sharing all of those resources. Folks, we have a couple minutes if people want to ask a question, or you just have something that you'd like to hear a little bit more about. Here, I'll unpin you. I do want to just emphasize what you just said about appreciating the knowledge that's been shared, Missy, and offer my thanks to all of you for sharing today with us. I think this has been, right, as we're seeing questions, I think people who are here are both interested in learning more, but also understanding how they can be active in the process. If somebody could drop a link, or I will while I'm talking, to the Indigenous Community Center's website in town. If you're in Douglas County and Lawrence, it's a great resource. And they're doing a lot with a group of volunteers, basically. So thank you very much, Kate. So that's one way to get more involved and educated. Other than that, seeing no other questions, I think I'll just let us go and say thank you very much to all of our presenters today, and to everybody who is here. And a reminder to keep your radio or internet tuned in on November 9th so that you can be hearing what's going on with the Supreme Court case. So thanks, everybody. Have a wonderful afternoon.